talking about estate planning for about between about an hour and 15 minutes to an hour and a half. And yep, you can see it. Excellent. And the purpose really today is education. We're big on education here. So what we're going to talk about is some of the key information you should know with regard to estate planning, common pitfalls that I've seen, our process, how we work with clients, and how we charge, generally, how we charge clients so that you can get a good understanding of what we do, what the key issues are, and see if this is we can see if this is the right fit for both of us. And so the one thing that I think is a great tool and that you should have in your handouts is there is a PDF called the Selecting and Working with an Estate Planning Attorney. These are the questions that I would be asking an estate planning attorney if I was in the market for one, knowing what we know. So we'll check back in towards everyone asks about price, which we'll definitely talk about, don't worry. But there's about 14 other questions you should be asking. And so we're going to go through those, and I'll check back in towards the end and see how I did. So you can be a good consumer and see if what works best for your family. And so with that being said, I will jump in and start. And so the purpose of this slide just gives you, I'm an estate planning attorney. Our focus here at Insight Law is estate planning and business planning. That's it. We're not doing personal injury. We're not doing family law. We're not doing other landlord-tenant law. We're doing estate planning and business planning. I'd say about 60 to 70% of our clients is just estate planning, and about 30 to 40%, just depending on the mix, is business planning. And we have a team of 10 here, so it's just not me. And so we got a good, strong team here. And that's the basic background as far as our firm. And you're going to find that if you work with us, if we work together, I'm a very blunt attorney. Most estate plans just don't work. How would you know if your plan worked or not, right? Maybe when would you know? Might be a better question, and maybe be too late after you're gone, right? And so my point today is let's think about, what you need to be considering. And the way that I approach it, I'm a visual learner, and so the way I approach it is let's take a step back and let's figure out what we want to accomplish and visualize it, right? And so not many people want to think about this on the estate planning side, but we're here today to talk about it, so let's focus on it. So the snapshot test is a test that I employ with regard to visualizing the estate plan. So I want you to kind of visualize the time after you passed away, and you're looking down from your cloud from above. All my clients look down; they don't look up. Right? Beats the alternative. But if money's going where you thought it'd be going, and people doing what you thought they'd be doing, then that's generally a plan that worked. Money not going where you thought it'd be going, people not doing what you thought they would be doing, probably a plan that didn't work, right? And you may have an idea of how that looks in your head right now. I just find that people don't know all their options, and that idea might be a little bit fuzzy. And so I think that's the attorney's role, is to give you information so that you can make an informed decision and have a clearer picture of how you'd want things to work out. Okay. And so the first thing I want to do is there's a lot of smoke screens out there in the estate planning world, right? And so one piece of advice I would or recommendation I would give is don't focus on the documents when it comes to estate planning when you're in the market for one, right? What I mean by focusing on the documents is kind of gearing the whole relationship with the attorney on what documents do I need? How much is it for a trust or a will or a medical directive, a power of attorney? We'll talk about all those and what those mean. But the point of that is if you're focusing on the documents, right, then that's a little bit short-sighted because they're important, right? But that's not, you're not seeing the whole picture. And so my analogy with that is I like the show, The Fixer Uppers. If you've seen that show, this is a couple called they're Chip and Joanna. They're a couple that goes out and renovates people's houses. Joanna's the one that sits down with the clients and gets their vision, their goals. How do you want the kitchen to look and feel, right? And Chip is the one who comes in, and he's the carpenter, and he comes in with his tools and makes it happen, right? And if you haven't seen the show, it's basically, if you've ever had a project, a construction or any type of renovation project. And so my point of that is, does anybody ask Chip or the carpenter what tools he's using, right? No, they want to see the end result. I want the kitchen counters and the kitchen to look and feel like that, right? And so my analogy with the law side of things is the documents are just the lawyer's tools, all right? Which one works for you? You got to get with the right, the right person to make sure that that's the right fit. But ultimately, you just want a plan that works for what you're trying to accomplish, right? And a lot of our clients' goals that we work with, right, is we just want to make life easier for the people that follow. If you have a spouse, for the surviving spouse, right? Make sure that I've got some disability planning. If something happened, God forbid, I have a catastrophic illness where that it's not a complete mess for the family, or and making sure that the wealth that you've worked so hard for is passed on as efficiently as possible, right? Obviously, other goals like saving taxes and probate things, and we'll talk about what probate means, are important too. But that's the point, is like, in our mission at our firm, okay, is, when someone passes away, right, the documents are not going to jump off the shelf and do the work for families, right? Because it's families doing the work, because they got to figure out and pick up the pieces and figure out how to manage all of this, right? And so typically I find that the people don't know how to do anything, and they go into the lawyer's office at that time during the grieving process and trying to figure all this out, and that process really doesn't work, right? And our mission at our firm is very clear, is that when we get that call, the death notification, or if there's some issue, major issue, we want to be able to say everything's in good order. Just be with the family. When you're ready to talk, come on in. We have a specific process to get you through it. We've got everything ready, right? And so that's what you need, or I think that's what most people need, is a guide and having a process to get through that. We don't want to be able to say, I don't know, think it might work. Haven't seen you in a while. Don't know if things are updated. Don't know what you've been doing. Come on in, we'll figure it out, right? That doesn't work, or at least that's not the way that we operate here. And so, again, it's really just a matter of what you're looking for and what works best for your family. So another trap that I see is people just focusing on taxes, okay? And taxes obviously are important, okay? And in the estate planning world, there's a couple different taxes that people don't think about. So the first one people kind of know, but maybe not, is the estate tax. And the estate tax does not affect as many people as it did anymore. And if it does affect you, great. That means you've done something good as far as you built some wealth up, right? But the estate tax exemption right now is as high as it's ever been. Now it's going to fluctuate, but right now on the federal level, you can die with up to $13.6 million worth of assets before there's an estate tax due. And over that, there's a 40% excise tax, okay? And that fluctuates over the years. And so that's going to go back down to $5 million unless Congress acts. And that'll come back down to $5 million on January 1 of 2026. And it's indexed for inflation, so we think it's going to land around $6.5 to $7 million, right? Great. And that may still not impact you, but it may. And so that's one issue, is, okay, is that the reason why you do the planning? Well, we want to make sure taxes are done, but that's not the only reason. And taxes can rear their heads in many different forms. And so there's also income tax issues when it comes to estate planning. Most of our clients have retirement plans, 401ks, IRAs, TSPs, 403bs, Roth 401ks, Roth IRAs, right? Self-directed IRAs. There's so many different IRAs out there, retirement plans. And if you know about that, right, there's tax implications on a lot of those, right? And so when you pass away, right, how does that impact the beneficiary designations? And there's been some laws passed recently called the Secure Act. They made it so, Congress realizes that, hey, we need to find tax money. Where haven't we taxed yet? Well, retirement plans. And so they've really started shorten the game with that, where No, we want to start taxing that when the money comes out of that. And so when you put that beneficiary designation, they're trying, if you make the wrong, if you don't make the right option, pick the right option, there could be some really negative tax consequences. And so you just need to navigate all this. And how do you know all this stuff? And maybe if you're in this field, this is all we do, right? And so this is there's a lot of nuances with regard to that part of it. And then the transfer trap, what I mean by that is just people are just focusing on strictly avoiding a court administration or probate after they die. And so, that's one thing, that's level one to me, is that you want to do that. But that shouldn't be your only goal. But if that is, then I will show you today how to do that. And basically, probate is just a government, well, not just, but it's a government audit of all of your assets when you die. They want to know to the with. They want to make sure that if you're going through probate, you notify all your creditors so they get to have their day in court. Any heirs, even if they're not listed in the will, they get to have their day. After everyone gets their shot, then whatever's left would be distributed out to the beneficiaries, and every penny has to be accounted for while the assets are tied up in the probate process. Completely avoidable if you want to do that. To me, that's level one. Of course, you want to do that. But if that's all you want to do, then I'll show you how to do that without any legal documents. You don't have to hire an attorney. Let's just say here, just go here, and then there's certain things that you can do on that, and we'll definitely talk about that. I just find what's really missing in the estate planning world is just working with somebody that, or a firm that will counsel you through your options and make sure that, go through the pros and cons and figure out what the right one fits for you. And so a lot of times that snapshot we were talking may be fuzzy for people, or you may think you have the idea, but you don't know how all the information. I find a lot of people don't. So let's get that snapshot in focus, okay? And I'm a person, I like fundamentals, I like basics. And so I think the first thing everyone, if they're getting into estate planning, is know what the definition of estate planning is. Know what you're doing, right? And I would ask the attorney that you're working with, how do you define estate planning, right? And so there's not a definition in Webster's dictionary or Black's Law dictionary on estate planning, or there may be but this is our definition, right? Our definition is not just my definition. I'm an instructor for the National Network of Estate Planning Attorneys. And so I like this definition because it has covers a lot of the issues and it gives you a good idea. So whatever works for you, but these are the main things that we want to look at when we talk about estate planning. And so the definition goes like this. I want to control my property while I'm alive and well. Never had a problem, client have a problem with that one, right? And then a plan for me and my loved ones if I become disabled, mental disability. And then I want to give what I have to whom I want, when I want, in the way that I want. And I find a lot of people don't know the ways they could leave their wealth to all their beneficiaries. All while assuring my wisdom is transferred along with the rest of my wealth. And so, yes, we're trying to set the bar high. We want to transfer that material wealth over, but if there's some non-material wealth, life lessons and values, this is a place we can try to issue spot for that if that's appropriate, right? It's not appropriate. If it's not appropriate, that doesn't work, then that's fine, but that's what we try to set the bar. And the other point of this definition is estate planning is not just death planning. I think the disability side of things is becoming more and more of an issue than it ever has because we live longer, right, with medical science. Our counseling philosophy, our approach to planning, right? There's a lot of different approaches. And so this is our approach. I like this one. It makes sure we cover all the issues. And so we call it the planning pyramid. And the way that our counseling philosophy kind of goes is that we want to work with clients with categorizing the issues with the most important issues towards the base of this pyramid, and then work our way up systematically with a strong process. So the first part of our process is just getting to know your specific situation, your goals, hopes, fears, and concerns, right? And then getting to know the lay of the land with regard to the family. If you're single, or if you're married, how is the spouse's health? How are they with the finances? We need to know any issues there. If you have children, are they minor children or are they adult children? Whole host of different issues for minor and adult children. And age doesn't necessarily equal experience with money, right? So how are the kids with money, or the beneficiaries are with money? How do they get along with one another? How are their marriages? Strong, shaky? Are there any health issues that we need to be concerned about right there, right? Or creditor issues that we need to be worried about? And so once I know the lay of the land, then we can provide recommendations to preserve wealth, expand wealth, and yes, save taxes. But I'm not going to come at you with a tax strategy without knowing your situation, right? There's a lot of different strategies out there for the tax side of things. Which one fits for you would be, the one that will present itself once we figure out all the other issues. And the other point of this is the preserving and expanding wealth component. We can have teammates there, right? And that makes the plan stronger. And so if you have a financial advisor, that's great. We want to make sure that we're working on the same page and communicating, because that's a great resource and assistance on the wealth side of things, right? And when we're talking about estate planning, we're talking about all your money, right? And your family. And so we got to figure out, or all your wealth and your family. So we got to figure out who the key players are on that. And so I find when people have financial advisors, the plans are stronger. Not a requirement. I'm just giving you our experience on that. And the basic idea behind the planning pyramid is that you teach us the family, we'll teach you the law, and together we'll make the plan work. Okay. The co-creative process. I am a bullet point person, and I get asked to review estate plans all the time. And really, these are if you boil it down when it comes to an estate plan, these are the four things that if I can check these off, I know you've got a good plan. And these are the things that we strive for on our side, right? Did this person get good personalized counseling, or is it just basic word processing that they could have gotten off of the internet, right? And I do spell counseling with two L's because I'm trying to make a point there that the attorney should be bringing something more to the table than just here's some get some biographical data and spit out some forms for you. And I find, unfortunately, that's what happens a lot of the times in the transactional approach to planning. And that may be what people are looking for. That's not what we do. Okay. And I tell people, if you're looking for a document, don't hire an attorney. Just go to LegalZoom or something. I think there's like a trust website, right? I just find that you're not going to get much counseling because you don't know what you're looking for and what you're trying to accomplish and what your options are with regard to that. And so today, throughout the discussion today, I'm going to be highlighting the difference between counseling and word processing. And we strive for being on the counseling side of that spectrum when it comes to working with the clients. Is that, hey, we're counselors here. Let's work this out. The second key point to an effective estate plan is proper asset ownership. And this is really critical because when you think about it, estate planning, a big piece of estate planning is making sure that the assets get transitioned from one place or one person to the next as efficiently as possible, as seamlessly as possible, with the most amount of protection, the least amount of taxes. And when you think about that, and that's where a lot of estate planning gets bogged down, is that people don't have their assets titled the right way. And so there's things that you got to go to court because you don't have the right to do this, or we're going to freeze these assets or this. And so you just need to know the rules of the game, and they're getting more complicated. I'm sorry. There's only three ways you can own your assets, though. That's a good thing. There's only three categories. You can own them in your individual name, you can own them jointly with someone else, and then you can own them by contract, okay? And sometimes it gets murky with people if you don't know all the rules on the joint side of things and by contracts. And contracts are things like, it's not just a contract that you work with if you have a business and the like, and you have operating agreements or shareholder agreements. Contracts can also be life insurance policies. Contracts are also retirement plans, IRAs, 401ks. Those are contracts, okay? Trusts are contracts. A bank's payable on death designation is the bank's contract, okay? And so you just need to know how to decipher them. And with all the forms that are out there and the slew of regulations in the financial world, you need a PhD in form reading to figure out which is the right option that you have out there. And so that's really critical. We take that really seriously here because I think that is probably one of the main pitfalls that I find in the estate planning world is improper asset ownership. Okay. And I'm hoping if you don't remember anything today, we're going to hammer that home today. Okay. And then number three is have a formal review process because things change. I'll show you how we responded to that. And then a controlled transfer process. You probably wouldn't be here listening to me today if you didn't care how things played out after you passed, right? So I'll get very blunt and make it real. And so let's say, what if you were to die today, right? And so let's make it right. If you were to die today, how prepared is your family if something happened to you today? And my point of that is, you're not here, right? Would they have any idea what to do, how to do it, or how to pay for it, right? And like I said before, I find people have no clue. They have not been advised of what the heck is going on. They are in the grieving process. If they can find the legal document, a lot of people can't even find the document. Maybe they'll find the lawyer's card. They stumble into the office at that point in time, one-on-one with the attorney who's charging hourly during the grieving process when things by studies have shown that things don't sink in. And it just takes a lot of time and expense. And they'll be like, why does it cost so much? Because the process, the traditional approach, it really doesn't make any sense. Okay. And that's where early in my career, after my third or fourth client passed away, I realized this is not a good way to do the planning. The traditional approach is very little counseling up front, try to get the client in and out so that you can go and get the next client. All right. And there's no follow-up, no maintenance, no education. And then when the death occurs way down here, we're trying to pick up all the pieces to think that something that happened 20 years ago is going to actually work. And that's just it's not reality. Okay. You just need to go through it one time to realize, oh, okay. And so I'll show you how we approach it. And I just find that that's a better way for me to practice law. We're not going through fire drills and the like. When people pass away, it's like we've got the plan, we've got a process, we're pushing papers. It's not a big dramatic on the legal and financial side, right? It's hard enough on the family as it is during the grieving process. Let's try to keep calm waters on this stuff here so we can get us through that. And I find that provides a lot of value. All right, so here's the 5 ways you can plan out there in the world, okay? So you can do no documents. I don't recommend that because there's a lot of risk there, and I'll show you that. You can, sorry, you can also do a will and a POA. And I'm putting POA down here on purpose because the estate planning world, I didn't come up with it. It has a lot of acronyms. It just seems like we're alphabet soup in acronyms. So I'm trying to get people to understand what the acronyms are and what they mean because there's a lot of misunderstanding. All right. So a last will and testament, right? If you go with I call that a will-based plan. That's like the main driving, that's the centerpiece of your plan, right? If you do that approach, then will drive the family to the probate process. Okay, that's someone asked me, oh, my family's not going to go through probate. I've got a will. No, will guarantees the probate process typically. Okay, and that's one point, and you certainly can do that. But I don't like to go to court, and so that's not what we do. But that's one approach. POA stands for power of attorney. There's 2 flavors of powers of attorney. There's a financial power of attorney and there's a healthcare power of attorney. Okay. Financial powers of attorneys, as you would think, are dealing with financial issues, and healthcare powers of attorneys are dealing with healthcare issues. There's 2 subcategories of financial powers of attorneys. There's what's called a general durable power of attorney, which is effective when you sign it, and it gives people blanket rights to do whatever. Okay. And then there's a limited power of attorney, which only takes legal effect after you've been determined to be disabled. Do you see the difference? Which one's right for you? It depends on your situation, right? And what we're trying to accomplish there. On the healthcare power of attorney, there's typically one, but there's some different issues within the healthcare power of attorney. But a healthcare power of attorney designates a healthcare agent to make healthcare decisions for you only when you cannot communicate to the doctor. So when the doctors feel like they're not able to communicate with you, even if you're blinking with them, they feel like you communicate, you're fine. But if that's the case where they can't find that they're communicating, then they go to the healthcare agent. Okay. The other point, the other piece of a good healthcare directive or healthcare power of attorney, and depending on your jurisdiction, they have different names. So Virginia uses the term advanced medical directive. A lot of jurisdictions use that. Same deal. But one component of a good medical directive or power of attorney is there's a living will component, your constitutional right to die if things get to a point where you're being kept alive on, with heroic measures on machines and the like. It's some of my clients call it the pull the plug document, right? And so that's what those are. And those are important, right? We want to make sure we got them, but that's kind of like the will-based plan, and that's all you're getting, okay? And you're leaving all the work to be done by the family after death. Very little planning up front, and it's less expensive, okay? Because you're not really doing much. You're just getting some stuff ready, get some order, and then let them deal with all the stuff afterwards. Okay. The next one is a will with a testamentary trust and power of attorney. So stick with me. Last will and testament. A testamentary trust is one that's created after death and with court oversight. Okay. I don't know why anyone would do that, but you can. And I guess if you had issues with a family and they're all contentious and there's going to be a legal battle anyway, hey, let's just throw them into court anyway and let them figure it out. Expensive, you deal with attorney's fees, accounting fees, you got to file with the court. Again, that's not us. If you want to do that, you go, I can probably find you some probate attorneys that's their business is set up for that. I never want to step foot in the courtroom, okay? And I don't want to have any of my clients do that unless it absolutely has to. Simple trust. Simple trust, I call these kind of bare bones trusts or basic trusts that you get over the internet or very little counseling done behind them. Yep, it's a trust. It's a contract, but do you understand it? Have you done everything right to make sure that it actually works? And that's usually finds the part where the funding component. Trust funding is a concept that deals with the proper asset ownership I talked about before. It's another term I will come back to. I didn't come up with the term. This is an estate planning term. You'd better know what that means if you want to trust, because most trusts don't work. And the first question I'll ask people is your trust funded? They have no idea what I mean. It means that you've titled everything properly to the trust, all right, in the trust or either to the trust. Don't worry, we'll talk about that. And then the modern approach is it's the process. Like I talked about, that's what we try to be. Is the modern approach is the documents are just part of the deal. Which ones work for you is make sure we get that into place. But it's the process. Okay, when we get that call, everything's in good order. Just be with the family when you're ready to go through this. We'll get through it, right? And so yes, it definitely, in our firm, we definitely use trusts because I think that just provides the most flexibility under the laws currently. If the laws change, I'll let my clients know that, but there's the most flexibility right now, and you can do a lot of great things with trusts if you know what you're doing on that side. And so I think these internal ones are like bare bones planning. Hey, I just need to get something done. I'm not really looking, for a process or a relationship-based approach with an attorney. I just want to document. Completely understandable and completely fine. We're not the people for that. Okay, go over on the internet. And if you do no documents, you don't need to do any planning. You're just not doing. You just leave it for the family to deal with. And we're more on the modern approach. So I'll show you how those things. So those are what you got on the spectrum of what the planning options are. And then here's your challenges in the estate planning world. Mental disability, I'd say probably one of the biggest challenges we have today. And the basic point behind that one is, and to be blunt, is that when you die, right, we're not having to, besides the funeral administration arrangements, that's the end of dealing with the actual person, right, as far as the physical. But when you're disabled, we got a whole host of other issues, right? My dad had dementia, and so it's not like it's going to be where is dad going to be? What kind of care is he going to get? Who's going to give him the care, right? Where's the money coming from? So there's a whole host of additional issues for mental disability, then it makes it harder, right? It's important, right? But it's harder. Asset transfer on death. I've talked about asset transfer a lot of times now. It's a big component. One of the biggest pitfalls in estate planning is I don't want to have to go through court or have people tell us that we can't transfer the asset to the next person in line. We want to have everything set up with the financial institutions with their whatever regulation that they've passed for the last week or so that this is going to work. Okay. Taxation, obviously, let's minimize taxation to the greatest extent possible. And as I said before, taxation rears its head in many different ways. And our goal here is to just avoid the gotchas. And we definitely got to work with your tax advisors if you have one, right? That's being part of a good team. So if you have a business, we got to make sure we're working things right with the business. If you got IRAs, do we have things right, coordinated with that? And so there's a lot of things that we got to look at there. And then just achieving your personal planning goals. If you have minor kids, right? How do we deal with the money with them? If we have adult kids, well, like I said, age doesn't necessarily equal experience. Do we give an 18-year-old $1 million, or do they need some investment assistance? Are we worried about if there's a divorce, there's a creditor, if we're worried about them getting a catastrophic illness, or if they're in a special needs situation? So it just depends on your personal planning goals, which we would go, through with you. So these are the challenges, all right? What I find is that's missing are a good process. And so our process to approach that, okay, and it's not the only process, but I like it, it's worked for us, is that it's an empowered approach, okay? We want to empower the design of your plans that empowers your legacy and empowers the inheritance for the beneficiaries. What does that mean? So empowering the design means let's not just get your biographical data, right? Let's figure out what your specific situation is. So step one is develop your plan with counseling-oriented planning partners, right? Where we talked about giving people their options. And what I mean by planning partners is if you got a financial advisor or a CPA or someone that is a trusted advisor, I want to make sure we're coordinating with them and we're all on the same page, right? The legacy component is just really keeping the plan maintained, right? And so committing yourself and your family to a continuing maintenance and education program. What does that look like? Where basically we're checking the vitals, okay, on an annual basis. It's not too onerous, but rather than completely ignore it, let's make sure we got the things right so that it's not a mess and we know where the assets in the right place, the legal documents are up to date, families prepared, so that when something does happen, that we can secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. Okay. And so that's it. Three-step strategy, three-step approach. The first step, let's dive into it. But before I get into the specific issues on it, let me just give you, that one of the planning traps that I see. And so if your only goal is to avoid probate, right, then I'll show you how to do that without even using any legal documents. We'll start with goal one. I've got a lot of engineer clients and they love formulas. So if you're going with the no document approach, or if your only goal is to go to avoid probate, basically everything that you own in your individual name at death equals a will equals a probate. Okay, and that's the government audit of your affairs after you're dead, completely avoidable if you want. So how do you avoid it without doing any legal documents? Here you go. You title things differently, okay? Here's where you can title your assets. So you can title things as joint tenancy with what's called right of survivorship or joint accounts, right? And you're probably familiar with like a joint bank account and the like. And the way that works, it's a legal form of ownership, where when one joint owner dies, the asset will go by operation of law to the surviving joint owner. Just take the death certificate down to the financial institution. It'll go outright to you, okay? Outright to avoids probate, okay? But let's play this out in reality. So let's say I'm going to introduce you to my favorite cast of characters. Let's say I call them, I'll do a married couple, Bill and Mary sample, okay? Let's say they have 2 kids. And so let's say Bill and Mary title everything jointly. So, and I always knock the husbands off first. You can do whatever you want in your plan. So let's say Bill dies. Everything There's a title jointly, everything goes to Mary. She avoided probate. Great. Now what? Everything's in Mary's individual name now. So now that Mary is in the grieving process, everything's in her individual name. Remember, everything's in her individual name. When she dies, everything's going to go through probate. So now we're going to burden the surviving spouse to figure out everything that really should have been just done up front the right way, right? Okay. And then the second issue or point there is if you're just thinking about adding the next person in line to the joint account, think again, because if you do that, they are owners of the account and all the baggage that they have and all the creditors that they have, or they get into a bad marriage or anything like that, and there's tax issues with that, they are owners and they can clear out the account and all of their baggage comes on, and the IRS wants to know about it too. Not a great way. It's a very dangerous way to do the planning. But it's an option. Okay. You can do what's called transfer on death accounts, which is, like I said, payable on death or these are the financial institutions forms. Just read the fine print on them. And sometimes those are a good approach, but it's not a one size fits all hammer, right? Fix everything type of approach. And so that's used in limited circumstances. And a lot of our planning is like, oh, and it depends on the financial institution's rules and whatever they decide that they want to put into their forms of that day, whatever their policy is. And so we've got a list of, okay, Bank of America does this, Wells Fargo does this place does this, right? So we figure out which ones work. And so it is a tool in the toolbox, but it is not the only tool that we use. And then the third one is planning with the box. What do I mean by planning with the box? That is those IRA forms or life insurance forms, things that have beneficiary designations, 401k. When you're planning, when you're filling out those forms, you're doing estate planning, right? Because when you die, that's where they're going to go. And the retirement plans, there's a whole host of legal and tax issues that are associated with it. And so a lot of times, a lot of our clients have a lot of wealth built up in those. We want to make sure we make the right decision and have the maximum protection, maximum efficiency. We did it the right way. Okay. So those are things you can do to avoid probate, is just do all those done. And then, I'm trying to show you there's pitfalls with that. Okay. So what do I mean by developing the plan with counseling oriented planning partners? Well, number one is we look through your assets like I was just showing you and figure out, come up with a plan for each one. But here's some common goals that we find our clients have in the estate planning world. Number one is catastrophic illness protection or disability planning, right? So if you did have that stroke or big illness towards the end of your life, right? Do you have a preference or do you have a view on whether you'd rather be taken care of at home or in a nursing home, or you don't care, right? And if you do want to be taken care of at home, where in your legal documents does it say that, right? And a lot of people say, I got that covered. I got a healthcare power of attorney or a medical directive. Like again, okay, because that's a document designating a healthcare agent. And it's just a laundry list of what they can do. It says you can check me into the hospital. You can check me into the nursing home. You can keep me at home and bring home care, and you decide, healthcare agent. I'm just saying, if it's that important to you, let's put it in there. And I'm not going to just give you a blank piece of paper to figure it out. We have counseling tools to get through that. And if you don't care, I'm going to tell you from firsthand experience, you're not doing your family any favors, okay? Because that's a huge burden to put on a family. My dad loved us very much. He just was very quiet and very personal when it came to his estate planning stuff, because that was just the culture. But it really hurts the family, because when you're in a situation where they are not, quality of life is really low and they're not able to communicate at all, okay, they're not the same person that you grew up with, right? Then that's a really tough burden to put on the family, to say, we're going to put you into a nursing home or something where, you got round the clock care at home, which is burdening the spouse or whoever the caregiver is. And if you've got the money to do it, great. Okay. He didn't. All right. And so the point of it is, let's raise the discussion and let's figure what out that is ahead of time, so it's not a huge burden. Okay. And so that's the better way to do it. I know it's a tough topic. Hopefully you never have to deal with it, okay? But if you do, it makes a lot, it provides a lot of value to at least hit the key issues ahead of time, okay? And so that is one of the main concerns with disability planning. And so one of the points of that is, would you rather leave instructions for your own care? And then finances, that's a big issue today is, my dad, as he got worse and worse, was sending checks to the wrong people and people were taking advantage of him. Okay. There's unbelievable people in the world that are just vultures that will just jump on things. And so the point of that is to protect all the wealth that you've built up. But when you take someone's control of their finances away, that's a big deal, right? And so we need to have a strong process. And we don't want to have to go through the court proceedings to do that because that's very expensive, time consuming, and it's a huge burden on everybody, right? We don't want to do that. And so is there a strong process to do that? Well, there's no perfect science to that, okay? But we try to at least be proactive and be as strong as we can. And I think, we've got a strong process on it, right? And we're always trying to get it a little bit better. But here are the three key issues that we find when we're dealing with the financial issues when someone is becoming disabled, right? Who's going to be managing the money and how do we deal with that? How do we protect, those types of things in the best possible way? The three questions that I find are, number one, when am I disabled? We got to ask. Who do I trust managing my money when I'm disabled? And what can they use the money for? So God, hopefully I never become disabled, but if I can address these three questions, at least I've got a decent plan for that. And so most legal documents say when two licensed physicians anywhere in the world say I'm disabled, I'm disabled. I don't like that approach because you don't know your doctor like you used to, like where you had time to spend with them and they actually knew who you are rather than they're looking at the computer the whole time, right? And so, but you need a medical component because you have to be, there has to be a diagnosis there. And so what we tried, our approach is let's create what's called a disability panel. And a disability panel is not making healthcare decisions for you. Okay. We're just talking about your finances. And so their only thing is if we were sitting around a table, here's the question for the disability panel. And their only question is to answer this. Does mom or dad or does this person have the ability to effectively manage their financial affairs? Okay. Yes, we need a medical opponent, but I always also find family is important too in that. So typically, if there's a spouse, the spouse and the doctor, because you just don't wake up one day with dementia or something, right? There's a timing component to that, or it could be other family members or friends, people that you trust, right, for that. So that there's a process here. This is the panel that I trust, and if that's triggered, then we pass that asset on to the next person in line that we trust that person's called the successor trustee, or we call them the disability trustee. And the trustee is simply, if we're using a trust, they're the person who has authority to manage the trust and legally bind the trust. Okay. Here, pass that box, pass that over to that person. They've got it. No court, right? Not a huge mess, but we've got an efficient transfer. And then let's go through some instructions where, I'm not going to give you a blank piece of paper on what you want, but here's some checklists that we have. Yeah, I want to be kept care at home. I want this. I want these people around. I don't want these people around. These types of questions that we want to look at. When, who, what? Catastrophic illness planning. I'm not going to talk too much about this. A lot of people call this Medicaid planning. So this really just highlights or underscores the fact that long-term care expenses have skyrocketed. There's a whole field out there, right? And it's not covered by Medicare or health insurance. And it's when you have, when there's things that you cannot do, what they call activities daily living. My dad couldn't bathe himself, dress himself, feed himself. He needed someone to be around him so he wouldn't hurt himself. Okay. And in a lot of jurisdictions, everything is, the expenses vary where you're at. But in the Northern Virginia area, if you're in that area, you're looking at 6,000 to 7,000 a month minimum for that kind of care. And I've seen it as high as $30,000 a month, maybe even more a month. So it blows through people's retirements, right? And it's gone. And so that's where if you're going to be in that situation, that's more of a, is there things that we can do to protect against that, right? So on our side, we do what's called proactive planning, where there's no concern now, but we want to just make sure we got things in place that if it does happen, they're in good shape. And versus crisis planning. Mom is going into a nursing home right now. I've got people I can refer you for that. They just do Medicaid planning and they deal with the state agencies. And Medicaid is the only government payer of long-term care expenses, but you got to be penniless. You got to show me you got less than $2,000 worth of assets. There's some exemptions. Again, I'm not going to go into detail. I'm just highlighting that's an area of law, and it's not cheap. Okay, most of these the estate planning, those of the Medicaid attorneys, or they call themselves elder planning attorneys. I don't care what you call them. Okay, they're doing that type of area. Their kind of basic fee is, oh well, whatever 2 months in a nursing home is, that's what we charge, and they're setting the fees at like 10 to 15,000 for 1 month. So you get the idea. But there's a lot of benefit to it if there's going to be 4 years of care. But the Medicaid, you don't want to ever be in a Medicaid bed. Okay, that's like the last resort. But if that's it, then you got to deal with it. All right. So that's enough about disability. Sorry for bringing everyone down. The remarriage protection is pretty straightforward. I'll use Bill and Mary, that Bill and Mary example again. They're a husband and wife, right? Couple. They have 2 kids, and so it's not about trust between Bill and Mary. It's really about the next person in line. So let's say I knock off Bill first, right? I always knock off the husbands first, and let's say they had a simple will, right? And they said everything, and it's very common. The "I love you" wills, very common, right? When Bill dies, everything goes to Mary. If Mary dies before Bill, it goes to Bill, and then when the survivor of them dies, it goes down to the kids. Very common, right? So Bill dies, everything goes to Mary, and let's say Mary meets Bo, the tennis pro, right, at the tennis club. She falls in love and gets remarried, and let's say that Mary's will says everything goes down to the kids when I die. If she predeceases Bill, no, if she predeceases Bo, the tennis pro, right? Uh, does Bo have a legal right to those assets, even though Mary said all of the assets go down to the kids? Absolutely. He has a statutory right. Depends on which jurisdiction you're in. Okay. Some jurisdictions say 50%, depending on length of marriage. Some say 30%. Some say 25. So you got to depend. It depends on the jurisdiction and how long you've been married. I find most jurisdictions now are moving towards a length of marriage for that second marriage to give them a percentage on that. And then let me teach you another point here, which is important. And the concept is that the legal title of an asset will control over the legal documents. Okay, what does that mean? So if most married couples have their assets jointly titled, right? So if Mary and Bo, the new spouse, right, had things jointly titled, remember I told you about that joint ownership? They're not looking, the bank account, the banks are not looking at the will. They're saying, oh, this is a joint owner, Bo gets it, right? If you have an IRA, okay, married couple situation, kind of the knee-jerk reaction, oh, if there's a married couple, we always put the spouse on as primary beneficiary. Well, that's a contract, and the custodian of the IRA does not look at the will. They look at the IRA. This person wrote this beneficiary, it goes to them. Okay, life insurance, same thing. So if there was a way that Bill could leave his assets to Mary, she could use it for whatever she wanted. But when she passed away, it had to go down to the kids, right? Is that something that's worth spending some time talking about? Is that counseling or is that word processing, right? You get the idea. I'm trying to show you that there's some issues, a checklist, and just figure out what's working for you, and let's just avoid landmines down the road. Creditor protection. This one's probably the more important one in our firm, and I use what's called the school bus story on this one. And so on the school bus story side of things, let me explain how that, I just find that highlights different issues. And this is an important story because I'm going to explain how there's a lot of misconceptions about trust, I'll introduce you to kind of the idea of a trust and where the benefits are from the asset protection side and where they're not. A lot of misinformation out there, I find. Okay, so let's say in the school bus story, let's say Bill and Mary sample. I'm using my same cast of characters, right? And let's say that Bill dies, and let's say Mary, after Bill dies, a few weeks after, Mary's still all distraught. She's in the grieving process. She's driving down the road. Maybe the kids are in the back making some noise. She's not paying attention. She runs a red light, bam, hits a school bus full of kids. And let's say a horrible fact, let's say one of the kids dies, right? Horrible situation. The world's against her. She hates herself. This is a catastrophic creditor. This is not, this is never intentional, right? But we're just going through and highlighting creditors. Someone said, Bob, you should say it's a school bus full of lawyers, and that would be easier. No, but I'm just trying to highlight a point. Okay, we have a catastrophic creditor there. And there's a couple different ways that Bill could have left his assets to Mary, and I'll show you the impact of the creditor on each one. So let's say there was a simple, they did the simple will, right? And the simple will says when Bill dies, everything goes out right to Mary. Mary hits the school bus, has the creditors, all those assets that Bill left outright to Mary, gone. Okay, subject to her creditors. Let's say they owned everything jointly. They titled everything with that joint bank account. They said, let's go with that approach. Great. Remember, I told you when one joint owner dies, it goes outright to the surviving joint owner. Can they put the lien on the house now? Sure. Can they do the bank garnishments? Sure. Creditors can take those assets, right? Obviously, if you have a mortgage, the mortgage is going to have a superior position, but the creditors can take any equity behind that. They can force a sale of the house, right? So that's the joint ownership. The third one is by contract. Let's say a life insurance policy wasn't worth a lot during Bill's lifetime, but let's say it turns into $1 million when he dies. He got $1 million. Mary's got $1 million check. She puts it into her account, hits the school bus, gone. Okay. Fourth way is by those simple trusts that I was talking about, or bare bones trusts that have very little counseling behind them. And I look at the dispositive provisions, and it says when Bill dies, everything goes out right to Mary. That stuff's gone. All right. So let's say we did it another, let's see if we can do the planning again. Let's say Bill did it a different way, right? Let's say Bill, if we could do it this way, where if something happened to Bill, he could leave his assets to Mary. She could do whatever she wants with those assets during her lifetime, but if she hit the school bus, it's protected from her later creditors, okay? And it doesn't have to just be the spouse. It could be anybody, right? So let me say that one again. Could leave his assets to Mary. She could use it for what she wants, but if she hits the school bus, protected from her later creditors. I want you to connect the dots here, right? Remember that definition of estate planning where I was talking about I want to give what I have to whom I want, when I want, in the way that I want. Let me ask you this question, kind of focus that in. How many of you would like to leave your assets to your loved ones that way, protected from their later creditors? And then the follow-up question is, how many of you have been asked that question before, right? Whose job is that, right? Would you know about that? So I think it's the attorney's role, right? Is that counseling or is that word processing? You may not want it, you may not care, but at least you should have an informed decision. Most of our clients say, yes, they've built up a lot of wealth, let's do that, okay? But again, that is a counseling decision, but you should be aware of it. Divorce protection, I don't spend much time on it. It's basically the same thing, almost the same thing. Oh, let me go back with the creditor side and the trust. So let me explain how that works with the trust. So think of a revocable trust. I don't have my little trust visual, but so a trust is basically just a contract, okay? And the way a revocable trust works is that it's like an open container where you can get in and out of the trust and do whatever you want, but your creditors can as well. And a revocable trust is not going to give you any asset protection, but a revocable trust is kind of one of our main planning tools. And it's important. It does a lot of other good things. But during your lifetime, it just doesn't mean, oh, I don't have to pay any of my bills or I'm shielded from all my creditors. No, that's not how it works. But when you die, You can put the lid over it and say, this is my hard-earned wealth for my people or for my beneficiaries. It's not for their creditors. It's not for their ex-spouses. Okay. With their money, you can do whatever you want with that, but this is my money for them. Okay. So that's under trust law. Huge, lot of case law on that, a lot of foundation on that. And one of the main benefits that you can do now, and so that I just find there's a lot of misunderstanding. We'll definitely talk more about trust, but that's one way you can do it. Very straightforward, and it's not it's not really that onerous to do. It's just building it, just build in the provision into the trust. You've already got it there. Just take the next step. Um, Divorce protection, same kind of concept. How would you like to assure that the assets that you leave to your beneficiaries stays with them and doesn't go with any what I call new outlaws, right? And so that's just divorce protection. Most people, and our clients like call it bloodline protection, right? Yep, I like that bloodline protection. Values promotion, I use what's called my babysitter story. This is that, your values, if we can pass those on. I got started a little bit later in life with kids. I have an 8-year-old, but when she was like 3 or 4, when we were trying to hire our first babysitter, the idea behind that was, the babysitter comes up someone's going to explain to the babysitter all the instructions. She's going to want to stay up late. If you read a story, read every page, because if you skip a page, she knows. I don't know how she knew, right? She's not going to want to brush, the teeth, may help her with those things. This is our neighbor's information. We're going to be here, but you get the idea. We're giving a whole host of instructions, and we're just going away for one evening for a dinner and a show. And so my point is simple. Would you agree that we leave more instructions for our loved ones when we're going away for just one evening for a dinner and a show than we even think about leaving in our estate plans when we're going away for a lifetime? Okay. And my point is simple there. And it's not like, oh, how do I don't have any values or that. This is the place where I'm not going to give you a blank piece of paper. I mean, if we can typically we'll be able to identify and record and memorialize them if we see those opportunities. Okay. It's not everybody, but it's the idea is if that presents itself, that's a great place to put it. And again, I think it's the attorney's job to kind of guide you on that. And I look at it like that's like the trip to the eye doctor, right? Where they're saying which one is more in focus, right? I can never guess. But my point is we're going to narrow down the options and we're going to co-counsel the plan. Which one you like, one or two, those types of things. All right. That's enough about counseling. I'm trying to give you an idea of a flavor on how we do it, at least. And what a good counseling kind of plan looks like. The maintenance side for you, right? So this is just making sure that the plan, the vitals are being checked and that we've got a base kind of understanding with that and things are on track, right? And very early on in my career, I would, I was really vehement about like, things change. Your life's going to change, your financial and personal situations, and the laws change. And the laws definitely change, and they're changing soon because just all the tax laws are changing in 2026 on the books. And that's the way the attorney's learning, right? So I've been doing this for almost 30 years, and so my plans look a lot different now. And it's the same thing with the attorneys. You're just getting the attorney's best shot. It's nothing that is wrong with it, but things change. We go to conferences, we get better, right? And I'm not going to argue that. I'm going to give you that one. And if you don't think things change, then we're probably not the right fit. But the idea is, I get that. And that's the people understand that. They just don't want to pay the attorney for that. And so I'm like, okay, let's focus on where the pain is, right? And where that is. So most attorneys will charge hourly once a plan is set up, right? And so my point on that is let's not charge hourly because people just won't call us because they'll be worried about getting nickel and dime. And I hate that. Okay. We're all about let's make the plan work. We have a mission. That's a better way to do the planning. But here's our maintenance plan. Okay. And it's optional. I'm not going to force anybody to do the maintenance plan, but it's a great value. And we've got a very high renewal rate. The renewals come in, they're always due the end of January, and we're like at 96%, and we just sent the reminders out, and we're usually at 98 99%, very high retention rate. So there's value there. But I'll tell you, our fee for the maintenance plan, okay, is $1,250 a year. All right. The first year we charge you a little bit more to enroll in our maintenance plan. We charge you $2,000 to get you set up on things. Okay, and I'll show you what we're getting you set up on and what this encompasses. What are you paying for, right? I'm not going to nickel and dime you for phone calls, emails, faxes, letters. If you have a question, call us. Okay, the way we do it, we schedule phone appointments. We're prepared. We're not playing phone tag, and I've got a way to do that. Right? Copies. Right? I used to work in a law firm where you had to put in the client code for every little penny. Right? Anything you did, you moved for a client, it was billed. Right? No, we're not doing that. Okay. Word processing amendments. Hey, someone moved, someone's name's changed, stuff that we don't have to sit down and do counseling for. We're going to do that. Okay. The other point is, and I think this is probably the number one value. I mean, if I had to rank them, is what's called the annual funding double check and ongoing funding support. That probably in itself is the value. And you need to understand what that means. Okay. And so let me explain what annual funding double check and ongoing funding support means. So we have a report that we use. So there's my favorite couple again. And it's called the Asset Review Report. So let me tell you. So when someone dies, right, the number one thing that anybody is charged for, whatever you do, a will, trust, whatever firm, whatever state you're in, they need an inventory of all the assets. Okay, boom, I hit a button. I know where all my clients' assets are. I'm not playing Sherlock Holmes to go find everything because we've got this asset review report, right? And these check marks by each account here mean that we've got a verification in the file that states that that account is titled the way we want it to be titled. So it's going to go avoid probate with the maximum amount of protection. RLT just stands for Revocable Living Trust. Okay. Why don't I have a check mark here, right? And so the initial setup of the plan is dealing with trust funding, is making sure, and that's part of we manage that process of, yeah, you're going to get your legal documents, but we're also, as part of our initial setup of your plan, we're going to put everything into your trust, okay, that needs to go there. Now, obviously, we're going to need your help. It's a team approach, but we're managing that process. That is a huge difference. So if you're comparing apples to apples, or if people are selling you documents, we're not doing that. We're counseling you, setting up a plan that contain legal documents, but we're also managing all the assets, okay? Not managing, we're going to make sure it gets into the right place. And so that's an important point there, okay? And so every year we send this to you. You got a portal, and you give us the new values of the assets. If you sold something, cross it out. If you bought something new, we add it. But if you buy something new, there's something called ongoing funding support I explained to you. We want you to call us ahead of time, and let's just get it titled up front the right way, because it takes a lot more time to fix the mess after rather than let's just get it set up. So we wanted that. That's part of our deal, is we'll help you with that as part of our routine maintenance. Huge report, okay? Number one, level one report. All right, I have a question here. Let me see what the question is. Oh, I'm only seeing Bobby, no other screen. Thank you very much. Let me make sure that I got this screen down. Okay, so let me put that asset report down. Thank you for letting me know. Can you see the asset review report now? So it looks like this. Thank you for letting me know that. And then let me make sure. No. Is everyone not seeing that? Let me make sure. How about now? Can you see it now? No. Can someone else let me know? Let me make sure we can see. So Diane, other people can see it. I'm not sure. Let me do this. Sometimes it might be on your screen. So let me not share. And then let me share again. Uh, can people tell me that they see? Wait, it's loading. The screen is loading.
You hear me? If you can hear me, we can see well, I can see the asset review report
Oh,
now.
okay, great. Thank you very much. Thank you. So that's again, so this is what we use. That's a very important report, and we're updating that on an annual basis. Okay. And that assures why we're not going to go through probate. And look, we're looking at the files each year. So we're not just leaving it out there. So we're not looking, we're going and doing the follow-up. Why don't we have the verification for the Apple stock? Because we know there's going to be issues with that. Okay. So again, estate planning is not just about the legal documents. The point there is that it's about also the assets that are out there as well. And we want to make sure it's all square with that. Okay, big report, big deal. So then the next point is a family meeting. So we don't do the family meeting every year as part of our maintenance plan. I'd love to be able to do that. It would just it would cost more. But we do want to do, and you always have the ability to call one. Okay, it's just an additional fee for that. But the point of the family meeting is it's part of our initial setup where we'll do a meeting, we'll huddle everyone up. A lot of times we do it through Zoom with whoever you want, right? And we go over you can go as high level or as detailed as we want over the plan, who's doing what, the 911 information. And if you don't have those people, ready yet or there yet, or they're not, we just got to figure those issues out. But the basic idea of that family meeting component is, yeah, we set the plan up. Let's make sure we know the backups know at least what their roles are, right? Level of detail we can always talk about and work on the agenda. Every year, as part of that maintenance, okay, you're going to get an annual group client meeting. I'm actually doing one on Saturday, so I do three typically each year in January and February timeframe, and it's a group Zoom type of deal. And what I'm talking about this year, I'll be very straightforward. I've gone through it a couple of times. Is I'll go through the legislation that deal with estate planning, the major ones, and the major ones this year everyone was talking about was the Secure Act 2.0 that deals with retirement plans and how that impacts things. So I decipher that and put it into kind of the way I talk, right? Explain that to the client base, explain what they need to be aware of, what the latest laws that are out there, what's going on in the estate planning world, what's going on in our firm. We're growing in our firm. We hired a new attorney, make sure everyone's comfortable with our process. And it's about an hour and a half, 2 hour meetings once a year, boom, Zoom, keeping us educated on the top level items. Every 3 years, we actually do group document updates, right? So we'll actually update your legal documents, but we do them in smaller kind of group format, and we have a very strong process for it. And the reason why, because most people can get those updates on a kind of on a consistent basis. They're not doing major counseling changes, and we're just making sure the vitals. Obviously, if you have a major change, we're going to huddle up and talk, and that's where we go into deeper dives. That's where the maintenance plan provides us with a platform to at least stay in touch, and then okay, let's do a deeper dive. Here's our second main report that we use. Let me make sure I'm sharing my screen properly. And so the let's make sure that it's working. Okay, so that, and just let me know, make sure. Yep, good, thank you. Thanks, Diane. So the estate planning review worksheet is just an executive summary of the key provisions, right? It's like your clip notes. You want to make any changes, right, to these people, the trustees, the beneficiaries, your healthcare agents, any of those things, your tangible personal property. So it's a great little report, right, where you can tell us the personal changes very simply. These are the things that we're changing. You send it to us, you upload it to your portal, and we'll put the legal technical updates. Oh, the Secure Act 2.0, I got to put these technical provisions in for the tax side. Boom. And we educate you on that. We have a process to do that, so you're good on that. But it really leverages everyone's time, and we're getting the updates done, and we're keeping everyone on track. Okay. Group educational programs, these are the ones just making sure that we stay on track with the the people, just knowing that you all understand the planning, but also the next people in line when they're ready. Okay. And so one of the big um, meetings that we do each year, this is our website. We have a client dashboard. Our clients wanted they wanted me to put it in bold, like the 911 info for beneficiaries and helpers, right? So these are a video that I do it live every year, and then I put it up on the website. Is the Saturday before Thanksgiving. I do it every year. So if something happens to the people, whether it's mom or dad or whoever the primary person is, what do we need to know? What's trying to protect against that situation where the family's clueless coming in. Now they at least know the first 3 or 4 things to do. I'm not going to make you an expert on it, but the idea behind that is we'll do that. DocuBank membership. Okay, so this is like having your medical directives online. So we have a relationship with another company called DocuBank. And I really like this service, and it's really dealing with your healthcare directives, okay? The healthcare directive is a legal document. This is practical. And so my point of this healthcare directive is every one of our clients will get a card, and we tell people sandwich that card between your driver's license and your health insurance card, because if you get into an accident, go to the hospital or the healthcare provider, they're going to want to know, number one, who you are, and number two, if you can pay. And this card just says my directives are here. There's an 800 number, and there's also a little member number and PIN number. Can be pulled 24 hours. I can show you how quickly I can pull mine. 24 hours a day, 365 days a year, right? This could be your helper can know where to do this. Or someone finds that 800 number, faxes 365 days a year, 24 hours a day, right? And so you're not scrambling to find your medical directives, right? Or the people that need it, right? And so and the other thing that I like about this, these are just little additional things. You can use as much of the services as you want or not. Medication list. My dad was on like 6 different medications, and we couldn't keep track of it all. It's all in one place here if you had that. Or medical snapshots are very helpful for doctors, like who your doctors, your specialists, vaccination histories, those types of things. Things that just make the plan go a little bit stronger, because it makes it, for me, it's very easy for us to think about our process, because we just look at it like, what is the best thing to do for the family? What things that we can do to support them? That's where all of our processes come from, okay? Digital assets, I'm not going to get too much into detail of that, but that's an evolving field. But what happens with your emails, your photos, and all those things, your Amazon account? If you have a domain, are they going to lose it, right? So we got to make sure we get those done, digital access. So that is something we are looking at, and it's evolving field, okay? All right. That is my attempt at explaining our maintenance plan, okay? And the idea behind it is we're just touching the vitals, a few hours each year, but this is what we're doing in the background, okay? And those things make things work, okay? That is the maintenance. And then on the third step this is when the rubber hits the road, right? When time comes, secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth, right? And so that, to me, is our driving mission, is making that as smooth as possible. So I don't know what appropriate assistance looks like to you, but with our clients, it's a lot of things that they want to make sure is, let's control the costs, let's get full disclosure of the cost so we can have true peace of mind, okay? And so now we're going to talk about fees for all you fee people out there. We're going to go through the fees and make sure I know it's important. So let's make sure we got that squared away. There's 3 things that you should know. To control costs in the estate planning world, there's a couple things that we found can be done ahead of time. Full funding, okay? Remember I talked to you about full funding. That's making sure we got everything titled properly in the trust that can go there. Now, I'm not saying don't leave here and say, the attorney said put everything in the trust, right? There's certain things we don't put in the trust, like your retirement plan, okay? But I want to look at the beneficiary designation on the retirement plan. I don't want to look at I don't want to put it into it. And so that's not your own retirement plan. And then we want to have what I call the proactive trustee and beneficiary. Well, the reason why full funding controls costs is if everything is titled properly, we don't have to go through probate. Okay, we sidestep that. We go to the next person in line. Now, don't misunderstand that there's nothing to be done. Okay, a lot of people think that, and we'll talk about that. But that avoids, we're not on the court schedule, okay, which is huge. The next is proactive trustee and beneficiary training. Well, that's that education point, right? Where rather than coming out of left field, they know our process, they have basic understanding, they know who to call. That makes the plan be stronger and makes our job easier, which translates into a cost savings, right? If the beneficiaries aren't moving stuff around haphazardly and just blowing up the plan. And we have a proactive engagement approach so that when you pass away, if you're on our maintenance plan, then we'll agree to do the administration at predetermined rates, which I'll show you, right? But we're not going to force your family to use us. We're not going to lock anybody in. I can't ethically bind that. Some people do want me to, but I can't. The successors have to hire us. Okay. We would say we're on our commitment here. They want to hire us at that time, we'll do it. Okay. And so those are the things to control the costs because we know the game plan. Okay, so that's number one. Now let's talk about full disclosure of those costs. And what is funding? I already went through that. That's the process of retitling the assets. And just to kind of hit it home, like your house, we would do a deed transferring it. Non-retirement account, we'd have to re-register the account with the financial institution. Okay. Now let's talk about full disclosure of those assets. So full disclosure, there's three sets of fees or costs at our firm. Okay, and every estate plan has it. And so whether you like it or not, there's the cost of the initial counseling and the documents, and most people get that, and most people are focused there. Then there's the cost of updating, and I find most people don't update or failing to update, right? That's the other cost. You saw our fee for updating, $2,000 to get you set up, and then $1,250 a year, optional. You can drop off at any time. I'm not going to lock anybody into it. Now, if you drop off, we're not all of our commitments under the maintenance. I can't guarantee you that I'm going to administer it at the rates I'm showing you because I don't know if the plan is up to date, right? And then the cost after death. People don't look at this. We don't want to talk about it, right? But I'm an estate planning attorney, but that's where most of the fees and expenses are after death. They're back end loaded. So let's be good consumers and look at the fine print. So this is, I'm just going to give you some kind of examples. Okay, and I put Virginia here. There's Maryland. There's Florida. There's DC. I will definitely talk about the fees in detail. So we'll get to that. So let's go through the back end. So if you have a will, right, this is what the probate schedules are. This is Fairfax County, Virginia. Every county is the same. So you say, I don't want to do the trust, or you did the trust but didn't do it right, where not everything was in the trust. This is the stuff. This is what the Commonwealth of Virginia says. These are statutorily reasonable guidelines. But you can, these are reasonable. We're a reasonable compensation state. You can charge this amount. And usually there's no questions asked when you charge in these guidelines while the assets are tied up in probate, right? While the assets are tied up in probate, they can charge 5% of the income receipts, right? So if there's any income coming in, like if you had rents that are coming in or bond interest payments or dividend income, 5% while the assets are tied up in probate, that's a reasonable fee. The principal, that means the underlying, amounts that you have. Let's say you had $1 million or $2 million, right? So the way that works is that the first 400,000, they can charge 5% of that. That's 20,000. The next 300,000, they can charge 4% of that, 12,000. The next, so you get the idea. It's on a percentage scale. Well, you say, well, Bobby, I'd like the trust. I don't want to do the will. Okay, and then this is Loudoun County. Every county is the same in Virginia. Maryland, just showing you Maryland's schedule. You gotta look at the fine print. Maryland says 9% up to the first 20 grand, right? So that's $1,800. plus 3.6 of everything over that. So they're at 3.6. And there you go. And then the fee's got to be approved by a judge there. And Maryland probate is a pain. I never want to do that. Then I put in Florida statutes here. Okay. And Florida statutes, I'm not presuming that you live in Florida or you own property there. A lot of people are actually moving there. But Florida, this purpose of this statute is to put two teaching points in the statute, because Florida has a very strong senior lobby. I mean, a lot of people go to retire in Florida. Would you agree? Some people call it God's waiting room. So Florida, they've got a very strong consumer protection contingent for seniors. They want to protect seniors there. Okay. And so this statute says this is what an attorney can charge. These are reasonable fees what an attorney can charge to do a trust administration, because there's a lot of trusts in Florida, and because there's a lot of seniors in Florida. You drive into Florida, I think they have billboards, hey, for trusts, right? And so they are big into trusts. And so they've put some regulations with regard to trusts. And so my first teaching point here, this is not probate fee schedules. This is for a trust. First teaching point is whether you do a will or a trust, when you die, it is a major life event. Okay. We need closure on every asset, every relationship you have, financial and legal relationship needs to be tied up and put in a bow, right? We need to take care of that. And so what the trust gets you is that you're just not on the court schedule. You still got to do the work. Okay. That's the first teaching point. The trust doesn't dump off the shelf and just do magically everything, transfer all the assets, inventory all the assets, make sure all the debts are paid, make sure the taxes are done the right way, right? That doesn't happen magically. People do the work, right? All right. The next point is they are such a strong consumer protection state. This paragraph 3 here gives you an idea. I can't tell you exactly what each person in the world pays for the trust administration, but this gives you a good idea of what the market rate is for what attorneys charge on a trust administration. And I'll boil down that paragraph 3 into one sentence, basically. That basically says that the attorney can charge 75% of what they could have charged on a normal probate, and that's reasonable. So in Florida, they're saying you get a 25% discount of what the normal probate fee schedules are. And let's look at their fee schedules, which you all have this, okay? And so they are more consumer protection. Their schedules are a little bit lower, but it's still done on a percentage scale, okay? So, they have, if you're 100,000 and 900,000, 3% of that. So you get 25% discount on that, right? 2.75. 2.5% from 1 million to 3 million. 2% on 3 million to 5 million. So you get the idea is it's on a percentage scale, probably more than you ever wanted to know. All right, so let me show you how we charge. So make sure we're clear. So we charge this way. We have a setup fee, maintenance, and after death. So on death, if you're on our administrator, I just talked about that part. So let me start there. At death, if your family wants to hire us, right, or the surviving spouse wants to hire us, we'll do the administration at 1.25% on the size of the net estate, only charged at death and only charged if we're hired. You just saw 5%, 4%, 3%, 2%, right? We're going to be below that because we have this maintenance plan. Because I'm not going to go through probate, right? I'm going to have an updated asset report. I'm going to have an educated family, right? We're going to make sure we got things in place. So the maintenance plan helps assure that. So yes, to set yourself up on the maintenance plan, to get us enrolled with DocuBank, get you enrolled on our portal where you have all of your legal documents on your portal, getting you all coordinated, right, on that is a little bit higher the first year. And then you're at $1,250 a year annually, optional every year after it, okay? You can drop off anytime. I don't want to force people to stay on it, but like I said, we have a very high renewal rate. The upfront cost to set up the plan, okay? And this is for non-taxable estates, which right now is, for 13 million for single people and 26 for married couples, right? So it's most people that are there. If you don't have to do advanced planning, right, on those things, we charge 0.5% on the size of your net estate, subject to a minimum of 5,000. Our maximum fee there is 13,500. Where you land there depends on your goals, your assets, and you'll know going in exactly what you'll be paid, because we don't charge anything until we know your specific situation and what you're trying to accomplish on that. Again, it's not just the documents, right? It's also the assets. So make sure you're coordinating and talking apples to apples on that. And so that's the way that we approach that. Now, the transactional approach, the traditional approach that I see, very little counseling done up front. So it's lower typically. They're not going to be managing and coordinating the assets. They're not going to do that, right? Here's some documents. There's not going to be any maintenance. Typically, I don't see many other firms. If you're on the national network of estate planning attorneys, you're going to have a maintenance plan, but most firms are not doing that. So that, and then at the end, that settlement is those fees that I was just showing you. Okay, so that's how our fees work. Hopefully, I answered the question that we had out there. That's what's the idea, right? And so, two questions my engineer clients always ask me, so I'll just get those questions off the table now. Is number one, Bobby, that sounds great, but what if something happens to you? I have more people worried about my health and welfare than I've ever had in my life. And so I would not be a good estate planning attorney if I didn't have a succession plan in place. So right now, I have an external succession plan with Ed Clay. He's agreed to take, he's a network attorney who I teach with, and he's agreed to take over my clients if I get hit by the bus. And I've agreed to take over his until my internal succession plan is in place. And I'm working on that. And we got about, 3 to 5 years. We're about 3 to 5 years out where we've got those in place. And so that's our approach. And then number two is, will that annual fee go up anytime? Yes, it will go up at some point. The last fee increase that we had, it was after 5 years. We did the fee increase and we raised the fee $75. So you get the idea. We're trying to keep pace with inflation, make sure things. So if 10 years from now, it's not going to be $12.50, right? It's not going to be $12,050, but it'll be, maybe $100 more or something along those lines. All right, so that's those two. And then this here is showing and make sure, is showing like our business model. So this is where we have less clients because we do more detail work, more counseling. And so I'm not looking for 600 clients this year, right? Or some I call those will mills. We're just to try and crank out as much volume. We're looking for 60, okay, not 600. And then, so less clients, better relationships. And then the maintenance side of things, it really has been a loss leader, the maintenance plan, the residuals are coming in. We're starting to get to the point where it's starting to break even. But we're going back to the cases every year, going back to the client's files, making sure that things are done right, right? I just could be devoting that to just finding new clients, but we have our team. And I not only have one funding coordinator, their job is to make sure everything is titled properly in the trust. We have two. That's how important it is, okay? And so that's what that does with the maintenance plan fees is to reduce stress for the attorneys, make sure we've got the overhead covered, that we're in business, right? And we've got a team of 10, so we're growing, we're on the right track. And then when you pass away, they don't have to hire us, but everyone does. And it's very predictable, the cash flow. Not predictable when people pass away, but it's very predictable that we get hired, and that really provides for a succession more. It's very attractive for other attorneys to get into this type of practice. So that's our business model in a nutshell. Okay. And so that's what I would ask the attorney is, okay, this is what your cost up front is. What's the rest of the fees, right? And so I'm a Paul Harvey fan. He's an old radio announcer. I'm dating myself, and he would always say, "What's the rest of the story?" The rest of the fees is, ask them, what are you going to charge me for trust funding? What are you going to charge me for the trust settlement administration, right? And the Trust Settlement Administration is, they say, I can't tell you that. Say, here's my assets. I die today. What would you charge my family? Right? You're probably not going to like the answer, but that's what I'm just disclosing all that up and in front. And yes, it takes care of, that's part of our deal, the death tax return preparation. And then the trick question is for the attorney is, what do you charge for probate services, right? What percentage of your trust-based plans wind up being probated? So if there's a lot of their trust-based plans going through probate, that should be a red flag to you, okay? We've had 3 plans go through probate out of 53 approximately. And those were things that I'm not going to blame them, but they just did. We kept telling them to do certain things, right? So you get the idea. That is the exception in our firm, not the only thing. Okay, yeah. So let me make sure I go to the fee. So yeah, basically, the fee is as follows. The setup of the plan is we charge 1/2 of 1% on the size of your net estate, subject to a minimum fee of $5,000. Maximum fee is $13,500. Where you land there depends on your assets, your goals, and we only charge you once we both have you have a specific fee quote and we both agree on that. The maintenance plan to enroll in year 1 is $2,000, and then every year after that, in December you'll get a renewal, and January 31st, $1,250 fee would be due. And then when you pass away, if the family wants to hire us, we'll do the administration at 1.25% on the size of the net estate. Hopefully that went over and you got that was being clear on that. And I think our process will address a lot of those issues. But my goal here is, as I'm giving you kind of the ranges, I don't know what exactly would be until I knew. Now, if you've got like 5 different, if you got assets in 5 different jurisdictions, 5 different states, and they're real estate, we're going to talk, right? So I need to look at the lay of the land to see what am I doing here? Because we're going to make sure everything gets into the right place. And usually a lot of it's driven by the type of assets that you have and how many accounts you have and the like. And please tell me you don't have a timeshare. But if you do, we'll talk about that. The cost after death. So this is just basically just kind of a summary. So that's where you're at. For our process, for the life of the plan, you look at the whole picture, it's around 1 to 2%. Okay. Again, it's got to be work for you. It's got to work for us. This is our approach to it. Very comprehensive relational approach. And hopefully that'll give you true peace of mind. There it is. There's all of our fees. There's no hidden fees. I'm full disclosure. We never do hourly billing. I guess we do hourly billing. The only time is like sometimes I'll have a client have like a one-off work on a contract or something where we typically won't do it, but we may do things. But if we can't avoid that, we would say that up in front. And so now we're coming towards the end. I'm a little bit over our time. Sorry. I will get this done. So the traditional planning versus the modern approach. Traditional planning, basic documents and questions answered. That may be where you are in life. Modern approach is so much more: the counseling, the funding, the maintenance, the updating, the education, all the stuff that I talked about. The next step on our side is, if you are interested in exploring further, then our process looks like this. You're right here right now. You tell Michelle, yep, we want to schedule a discovery dialogue. There's no charge for that. It's about an hour to an hour and a half meeting with our paralegal. They're going to do a goal exercise with you. They're going to go through your personal information form, because we're literally going to see how your assets are kind of, and they'll give you a good fee range saying, hey, you're going to be right here around there, right? And then the next meeting is an initial interview. That's with me. We're going to go over engagement agreements, scope of services, a specific fee quote, and we're going to decide whether to work together. Okay. It's a joint decision. I'm at a point in my life where, we're very strong, we feel, and very good at what we do. And so I just want to work with people that see the value. And so that's where we're at there. And then on the design side is we're going to make sure that we get all your instructions set up. That's kind of like that trip to the eye doctor I was telling you about. And make sure that we get all of your instructions, that you know the instruction. That's usually 2 to 3 hours. I would never keep you in a room more than 2 hours, or do a lot of the stuff through Zoom. And then there's a delivery review meeting where we'll review the legal documents with you, make sure you understand them, answer any questions, sign, witness, formalize, make them legal. we're not done, right? Because we're doing things the right way. Then we'll have a financial strategy meeting where, number one, we're going to make sure we have an accurate inventory of your assets, that asset review report. And we're going to talk through each asset and make a plan for it and make recommendations for it. Your financial advisor is welcome to come there if you have one, or any of the meetings. It doesn't matter. But that's the main one. And then the funding meeting is where our funding coordinators, either Ginny or Taylor, will get all those magic forms corralled to get everything in the right the right buckets, the right trust and the like. Optional family meeting. Oh, my little screen is messed up here. Optional family meeting, no additional charge if we do it within 6 months of the delivery meeting. I'll go over the plan as high level or as detailed as you want with whoever you want. And then you're just on maintenance, right? Where we're checking the vitals. So the heavy lifting is up front. A lot of people ask me, how long does that process take? You can have your documents in your hand if you're motivated within 6 to 8 weeks. We do them like 2 weeks at a time, keep the plan going. Funding takes a little bit longer, but you've got the plan in place. It's really just getting stuff back from the courts or financial institutions and the like, verifications. And so let me just see how I did, and I'll let you all go. And if anybody has questions, let me know. Just type them in. You all have been good about typing in questions. So this is why we're asking these other questions, right? Tell me about your interest, background, and experience in the planning field if you're looking for an estate planning attorney. If they're a jack of all trades, that should be a red flag. Hopefully you got the point that this is enough information where this is all we focus on, right? And then how do you define estate planning? You remember that, right? What's your counseling philosophy? That is our that planning pyramid. Get to know the family, then present strategies. What's your process for working with me? I showed you my process chart. Process produces predictable results. How will you counsel with me to design my plan? I use visuals, I use stories. That's the way we do it. How do we assure, this is a good one. How do we assure my assets are controlled by my instructions contained in my planning documents? That's the funding question, right? Who's responsible, you or me? We're responsible, okay? We're managing that. You got to help us, but we'll make sure it gets done. How do we assure my plan stays current with changes in the law? That's our maintenance plan. That's easy. What's the level of involvement of my family in the planning process? Usually more involvement's the better, but every family is different, so we just got to figure it out. How do you charge for services? I probably went ad nauseum at it, but specifically, how much will my estate be charged after I'm gone? If they're a living trust attorney, what's your record with regard to probate? What percentage of your trust-based plans wind up having assets probated, right? We're like 53 and 3. Do you handle the filing of the death tax returns if they're necessary? Yes, that's part of the deal. What happens if something happens to you? That's my succession plans. How do I prepare for our consultation? Just complete the personal information form. And someone asked about, will you call me? Yeah, Michelle's great with follow-up. She'll reach out and see if you want to proceed, go forward. We don't want to force anybody to go any further than they want to, but yes, we'll ask and see if you want to proceed. So we'll definitely reach out. What type of service should I expect from you? I just believe everyone having a team approach is the best way. And so, yeah, you're going to work with everyone on our team because we're going to be so much stronger that way. Funding, you're going to work with Taylor or Ginny, me on the counseling side of things, scheduling and all those things, Michelle, support attorneys, Wendy, and we have other attorneys. So those are the things that we're looking at. Do you expect any commitments from me? Just think through the stuff I talked about today. Think about what goals are more important to you. You don't have to come up with who the backups are. The helpers are your backups, but come up with candidates, right? And then we'll talk about them. Do I have a current inventory of assets? So critical. What advisors can I involve? And usually a financial advisor is good on that. So with that being said, I'm going to conclude the presentation. Thank you, everyone. Hopefully it was helpful to you. This has been Bobby Fazy, president of Insight Law, and we've been talking about estate planning today. Thank you very much.